So you'll be able to view that and to see this webinar afterwards as well. So we'll be sending the recorded version of it probably a couple days after the presentation, but you will be getting a PDF copy of this webinar right after this has ended. So thank you. Where are we located? We have two offices right on Beacon Hill over here at 1 Ashburn Place and 100 Cambridge Street in Boston, but we also have offices throughout the state. We have offices in southeastern Massachusetts and downtown New Bedford. We've got offices in central Mass and downtown Worcester, and we have an office in Springfield as well. But like I said earlier, the Community Engagement Division, we're partnering with different divisions throughout our office and making sure that we can be present wherever there is need. So if you live in a place that does not have an Attorney General's office, we can still come into your organization. We can still partner up with local governments and come in and try to bring the resources of our office and expertise to your community as well. And we're more than happy to answer the call if you'd like to reach out to us or you'd like to email us. We'd be more than happy to either give out a presentation or to bring people from our office. The next slide is a little bit of a primer of our Public Protection and Advocacy Bureau. They're our most forward-facing bureau. When you call our office, you're most likely going to be speaking with someone from Public Protection and Advocacy. They do things like protecting students against predatory or for-profit schools. We're going to be talking a little bit about workers' rights, and they ensure that workers are paid the wages that they're owed. That's our Fair Labor Division. We make sure that civil rights are maintained and adhered to in Massachusetts and that discrimination does not happen. We also make sure that consumers are protected under Massachusetts general laws and that they receive the consumer protection that they deserve as well. Now that we have that, we're going to be going into the workers' rights presentation portion of this presentation as well. Kate is going to be here and she's going to be talking a little bit more about that. But again, thank you for being a part of our presentation. We really appreciate it. Kate, why don't you go ahead?
Hi, good morning, everyone. My name is Kate Watkins. I'm an attorney in the Fair Labor Division. And in the Fair Labor Division, we enforce some of the laws that protect workers in Massachusetts, particularly with regard to wages, certain breaks and leave time from work, and record-keeping laws. Federal law has similar protections, and whichever law is more protective of workers is the one that applies. These laws protect all workers in Massachusetts, regardless of immigration status, regardless whether the worker is working on the books or off the books, and even when a worker has agreed to work for, say, less than the minimum wage, they still have the right to recover the wages they should have earned under state law. The minimum wage in Massachusetts right now is $11 per hour. I will describe later that minimum wage will be increasing at the beginning of the next year. Workers in Massachusetts also have the right to overtime, so that's time and a half, their regular wages for hours worked over 40 in a week. Tipped employees also have a right to the minimum wage. The difference is that employers can pay some tipped employees a lower wage, which right now is $3.75 an hour, as long as the tips that the employee makes bring them up to the minimum wage. So if the service rate plus tips over the course of a week results in an average hourly rate that's at least $11 an hour, and that's what the law requires. If the average rate is less than $11 an hour, then the employer has to make up the difference. Another important things to know about tips is that they are considered wages. So employers can't retain or demand any part of employees' tips. And if the employer has a tip pool where service employees, so say wait staff, bussers, if it's a restaurant, pool their tips and share them. No one with any management responsibility, and certainly not the employer, can take part in the tip pool. The service rate and the minimum wage will increase in January and then each year for the next few years. In January, the minimum wage in Massachusetts will be $12 an hour, and the service rate will go up to $4.35 an hour. After the programmed increases end in 2023, we'll be at a $15 minimum wage. A core principle of the Massachusetts wage and hour laws is that employees have to be paid for all time that they work. So working time includes any time that someone is doing something for the employer, but it also includes any time that someone spends at a location because the employer required it. So if someone has to stay behind and cover the phones, or if someone's working alone in a store but business is slow and so they're studying or reading or doing things really for their own purposes, that's still considered working time because the person can't leave. Travel time between work sites during a shift is also working time. So, for example, folks working for a house cleaning service should be paid for the time between houses at least minimum wage when they're traveling from one house to another. Generally, the time that someone spends going from their home to work or the first place they're required to be by their employer is not compensated, and also the commute home after work does not need to be paid. And if someone is working, coming in early to work, staying late to work, or working through unpaid breaks, then they have to be paid for that time if the employer knows or should know that that work is being done. There are some exceptions for people who are on duty for a shift lasting more than 24 hours or more. They can agree in writing beforehand that certain meal periods and sleeping periods will be unpaid, even if they're required to stay on the premises, as long as they're not actually doing an active work. Once wages are earned, employers generally can't take out or demand any money from those wages. There are a couple of exceptions to this. One, of course, are deductions that employers have to take out of wages because they're required by law. So these might be FICA contributions or court-ordered deductions like wage garnishments or child support. Employees can also authorize employers to take money out of their pay for something that benefits the employee. So examples might be contributions to a healthcare savings account or a retirement savings plan. Again, as long as the employee said it's okay and it's for something that benefits the employee, the employer can make those deductions. Other than that, there generally aren't reasons that an employer can take money out of employee wages. Examples of common but not allowed deductions include cash register shortages or recovering the cost of damage to property if something breaks. Those are considered the cost of doing business, and they have to be borne by the employer rather than the employee. Also, uniforms. Employers cannot require employees to pay for their uniforms or take a deduction for them, or the cost of uniform cleaning if the employer requires it. Those are costs that the employer has to bear. Employers can make deductions for what are considered clear and established debts. An example might be if an employee asks for a wage advance and agrees beforehand that that wage advance is a debt that will be repaid through future deductions from wages. That could be something that would be an allowable deduction, even though it's not required by law or authorized by the employee for their own benefit.
Okay, we did have a question that are these deductions based on full-time and part-time employees?
Yeah, the same standards apply to everyone.
And one more, can the employer cost of employee transportation to and from work be an allowable deduction?
It depends on the circumstances. If an employer requires an employee to take that transportation, then it would not be an allowable deduction. If an employer offers, the option of taking some transportation that's provided as a convenience to the employee, say from near the employee's home to the work site, and that's something the employee can agree to voluntarily, that might be an allowable deduction. In Massachusetts, there aren't laws that apply to the short breaks that employers might provide throughout the day, but there is a requirement that employees working a shift lasting more than 6 hours get a 30-minute meal break. During this meal break, they have to be free to leave the premises, and they have to be free to do whatever they want and aren't performing any services for the employer. If these two things are true, then the break can be unpaid. Employees can voluntarily give up their meal break and agree to work instead of taking their break, but then, of course, they have to be paid for that time. These protections that I'm talking about apply to employees. Some individuals are classified as independent contractors, which means, among other things, that they don't have the right to, say, minimum wage or overtime or other protections like unemployment benefits. In Massachusetts, everyone who performs services, every individual, is considered or presumed to be an employee. In order for an employer to properly classify someone as an independent contractor, they have to show that all three of the following things that I'll discuss are true. First, they have to show that the person performing the services does so free from the direction and control of the employer or purported employer. That the services the person provides are outside the usual course of the employer's business. So, for example, a law firm that hires someone to come in and paint. And that the person who's doing the service is doing so as part of their own business, their own independent trade. They're basically a sole proprietor. They're in business for themselves. If any one of or more of those things is not true, then the person has to be an employee. It's a very high standard. And the reason we care about this so much is because it's bad for workers, it's bad for the public at large, and because it hurts employers who are doing the right thing, classifying their employees, giving them the required benefits of employment, and find it difficult to compete with employers who aren't doing those things. We get a lot of inquiries about personnel records. So in Massachusetts, employees have a right to see their personnel records and review them twice a year, and also any time that anything negative is put in the employee's personnel file. The employer has to notify the employee that that's being done and give them an opportunity to review the record. If an employee contests the negative information that's been added to the file, they have a right to submit their own written response, that then becomes a part of the personnel file and has to be included any time that file is given to a third party. Next, I'm going to talk about some of the newer laws that we enforce. Massachusetts, like many jurisdictions across the country over the last few years, has begun to require employers to provide job-protected sick leave to their employees. Beginning in July of 2015, employers have to allow their Massachusetts employees to earn and use up to 40 hours of job-protected sick leave per year. Almost everyone is entitled to this. It includes, part-time, seasonal, temporary, per diem workers. You don't, like many employer plans might require someone to work 20 hours a week before they're eligible. That does not apply to earn sick time. As long as you're working, you're earning sick time that you can also use. Employees can earn this time either as they work at a minimum rate of 1 hour for every 30 hours they work, or employers can give out earned sick time in lump sums that are at least equivalent to 1 hour for every 30 hours worked. If an employer has 11 or more employees, then the sick time has to be paid. And that includes, for determining the employer size, that includes employees outside Massachusetts or who are not eligible for earned sick time. But if they have 11 or more employees, then the Massachusetts workers get paid sick time. This time can be used to care for the worker, himself or herself, or for their child, spouse, parent, or a parent of their spouse. It can be used for acute medical needs like illnesses and injuries, and also for routine and preventive care. It can be used for mental health care, and it can be used to address the effects of domestic violence for the worker or the worker's child, whether they are otherwise covered by the Earned Sick Time Law or legal consequences, for example. The Earned Sick Time Law in that regard overlaps to some degree with another protection that requires larger employers of at least 50 employees to provide up to 15 days of unpaid leave in a 12-month period to attend to the effects of domestic violence and also other forms of abusive conduct. It is job-protected leave like the Earned Sick Time, and if the leave is used for a purpose covered by Earned Sick Time, then those two leave programs can run concurrently, and the employee can use their paid sick time for part of their domestic violence and abusive situation leave. Another of the newer protections, but it too has been enforced for more than 3 years now, is the Domestic Workers Bill of Rights. Even before this law went into effect, domestic workers in Massachusetts had most of the same protections as other employees. This Bill of Rights affirmed that and also gave some additional protections to domestic workers. Domestic workers covered by the law include people who care for individuals in their own homes or who care for the homes themselves. So nannies, companions, health aides, house cleaners, housekeepers are common examples of domestic workers. It does not apply to personal care attendants under the Mass Health Program or to casual babysitters. And it applies to people who are employed by the household or employed by a company that's hired by the household. So, for example, a house cleaning service. The Domestic Workers Bill of Rights gives domestic workers additional rights regarding the information that they have to receive about their employment ahead of time, the right to an agreement if they work sufficient hours each week. It further limits deductions for food and lodging, gives guarantees some days off per week for workers working 40 or more hours, and has additional protections for live-in workers who are vulnerable when their employment ends, not just because they've lost their job, but they also are losing their place to live. All of these laws are subject to protections against retaliation. That means that an employer cannot take any adverse action against an employee because that employee has engaged in a protected activity. And that protected activity might be complaining to an employer or a coworker or a community organization or our office or anyone else about a violation of the wage and hour laws. Retaliation is defined very broadly. It's really anything that's meant to punish or discourage an employee from exercising their rights under the law. And it, of course, can include firing an employee, but also changing work hours, taking away hours, reducing pay, making reports to immigration authorities, or threatening to do any of those things. We enforce these laws generally as a result of complaints that we receive, either from workers or from other individuals like customers or competing employers. If we receive a complaint and decide to open up an investigation and determine that laws were violated, we can take enforcement action, either civilly, which is usually in the form of a civil citation that orders an employer to pay any wages owed and also a penalty to the Commonwealth. But we can also take criminal enforcement action against employers. I've talked about a few of the laws that we enforce today, but we also enforce others that protect temp workers who work for staffing agencies that send workers to their client companies to perform services. Prevailing wage laws that set the minimum wages that must be paid on public construction projects and other kinds of public works in Massachusetts. Child labor laws that regulate the employment of workers under 18, and record-keeping laws, so the records that employers have to keep of the time worked and wages paid, and also the records they have to provide to employees in the form of pay stubs. In addition to our enforcement, workers can also enforce these laws themselves and sue their employer for wages. If a worker wins in court, then they must receive 3 times the wages owed, plus cost of litigation and any reasonable attorney's fees. Workers who are interested in suing their employer or trying to recover wages on their own are invited to attend our monthly free wage theft clinic, where they can meet with lawyers and other advocates to talk about their case and get advice. They might also get concrete assistance with steps like writing a demand letter or filing a court complaint. They may also find a lawyer to represent them. The clinics are held monthly in Boston at Suffolk Law School, and we also hold clinics in southeastern and western Massachusetts. And all upcoming clinics are listed on our website. We notify workers who have filed a complaint with us, but whose case we're not going to open for investigation of the upcoming clinics, but anyone is welcome to come. If you have more questions about the laws we enforce, the information that I've discussed today and more is available on our website, mass.gov/AGO, and there'll be a link to workers' rights. You can also call our Fair Labor Hotline, and the number is listed there, 617-727-3465. On our website, you can also find a link to filing a complaint online with us.
Thank you, Kate, for that, and I really appreciate all the help and describing workers' rights, how our office enforces workers' rights and workplace rights in Massachusetts. Again, if you have any questions for us, you can definitely reach out to us, AGO Community Engagement at state.ma.us. We'll be more than happy to answer any of your questions, or if you want to schedule a training or anything like that, we can definitely help out. Just a reminder, this webinar is being recorded. We will send out a copy of the video once we've edited and got everything together in a couple of days. Today we'll be sending out a PDF copy of this webinar along with a link to a survey. The survey is about 10 questions. If you don't mind answering that, it really does help us out. It maybe takes a minute to 2 minutes, but it really helps us out. If you are interested in any other webinars, we'll be hosting 2 more webinars in fall. We'll be having one on October 9th on identity theft and scams prevention. We'll also be hosting a webinar on November 13th on nonprofit solicitation and the best practices for giving wisely. That's a good presentation for anyone who's involved with a nonprofit organization or anyone who would like to know about our office's role in regulating nonprofits and public charities in Massachusetts. You can sign up for those by going to massago.eventbrite.com. There's sign-ups for all of those up there as well. So thank you again for being a part of our presentation, Tim.
Yeah, we just got a couple more questions before we end here, in case this is something that you had mentioned. But can you just speak to how the rules and regulations that you were talking about apply to undocumented workers, and are they able to file anonymously with our office if they're more comfortable with that?
Yes, so undocumented workers have the same rights under the wage and hour laws as any other workers. Anyone can file a complaint anonymously, but I have two things to say about that. One is that there is the option of someone filing a complaint, giving us their information so that we can contact them and follow up, but making it clear that they don't want their information disclosed to the employer. We prefer that so that we can get more information, and it also makes it easier to make sure that we know who's working for the employer, even if they're and can get restitution for them if that's warranted, if they're not on the employer's record. We don't share the complainant's information or identify the complainant to anyone. So if someone asks for a copy of a complaint that's been filed after a matter is closed, we do not disclose the personal information of the person who filed the complaint. We also don't share it with other agencies like immigration authorities or anything like that. We use that information for our own purposes. Depending on the nature of the complaint, if we can't tell the employer who filed the complaint, we might not be able to follow up. If someone says they didn't get their last paycheck, there might not be very much we can do if we can't tell the employer that so-and-so said they didn't get their final paycheck and try to resolve the problem. But there are many kinds of complaints that we can investigate without telling the employer who filed the complaint. So if someone complains and said no one's getting overtime, that's something that we can often go to the employer, look at their records, and determine whether there's a violation that way. But again, it's really helpful for us to be able to contact the person who filed the complaint to get more information. But it's not required. You can file a complaint and we will review it even if there's no contact information there.
And sort of just following up on that, if they're fired or there's some other thing that happens to them because they file this complaint and they are an undocumented worker, what protections exist for them in that situation?
Well, we would investigate whether there was retaliation, and we can take enforcement action against the employer. For some kinds of, in some circumstances, there can be restitution to employees who were the victims of retaliation. And if whenever we contact an employer, we do warn them, make sure they're aware of the retaliation laws, and that we're looking at that and watching out for it.
And just a couple more questions before we end here. And I'm not sure how much you can speak to it, but what's the criteria that FLD uses in determining if something's going to be a civil citation versus a criminal proceeding versus, a complaint that gets a PRA letter? Okay.
Well, we receive thousands and thousands of complaints a year, so it's not a judgment on the merits of a complaint if we don't decide to open an investigation. We do try to conduct investigations that represent, a variety of industries and kinds of complaints. Some laws we can enforce both criminally and civilly, and some we can't, so that goes into partly why the determination whether to enforce civilly or criminally. And most of the enforcement action that we take is civil enforcement.
And finally, what are employers required to provide employees in terms of information about their workers' rights? Do they have to give them the handbook? Is the posters?
So in all workplaces, the employer should have a wage and hour poster posted, and that notifies employees of the current minimum wage, but also other protections like about overtime and pay stubs and earned sick leave. They're also required to post a separate notice of the earned sick time law, and either give a copy of that notice to employees or include the employer's own sick leave policy in their handbook. There are certain situations where employers have to provide or post information related to employment in the workplace or give that information to employees. So domestic workers have to get a notice of their rights, and in some circumstances have to have a contract in place, a written contract in place. Temporary workers, for example, have to get notification of the details of their job assignment and the wages they'll be paid and other details of their work. Employees engaged on a public works project, the employer has to post or have information available relating to the prevailing wages. So there are other information in different kinds of workplaces that have to be provided.
All right.
Oh, and employees should be getting a pay stub that tells them what they've been earning, how much the employer thinks they work, so they can understand their wages.
Yep, and on this slide you see links to our website where you can find out more information about wage and hours laws, domestic workers, Bill of Rights, earned sick time, and much more, including other hotlines throughout our office, such as the Civil Rights Hotline, our Elder Care Hotline, Medicaid fraud tip line, insurance fraud tip line. Like I said beforehand, our office deals with a lot of different issues in addition to workplace rights issues as well. But our Fair Labor Division is here. They're more than willing to take your questions, your calls, your complaints, and to help out in the best way that they can. So thank you again for joining into our webinar presentation. Do we have any other questions?
Nope.
All right, so we're going to let everyone go. So thank you again, everyone. All right.